Good afternoon, one and all present over here. Marathwada Legal General Education Society's MANIKCHAND PAHA Law College, Aurangabad, organized 1 week lecture series on Code of Criminal Procedure, Juvenile Justice Care and Protection Act, and Probation of Offenders Act. Friends, this is a second day of our lecture. Today we have Dr. Pankaj Umbarkar sir. He is assistant professor from Symbiosis Law School, Hyderabad. He will guide us on the topic of Introduction on Juvenile Justice Care and Protection Act. Before proceeding further, I would like to introduce today's guest. Dr. Pankaj Umbarkar is an assistant professor of law at the Symbiosis Law School, Hyderabad, where he teaches upper level required and elective course and leads initiatives to focus on the social justice lawyering, practical and spiritual development, professional advocacy. As a former legal practitioner, Professor Pankaj brings his experience into the classroom and law school community. He taught number of subjects in MANTS Law School, Raipur, SLSH, including the legal aid, constitutional history, law of evidence, code of criminal procedure, discriminative justice, and so on. He also keep his interest in the international law. He used to teach the student in more dynamic way and the skills. He has been honored by the Moot Court Association of SLSH of his eminent support and effort to help the student in research and argument development in 2020. Sir is a member of various committees, mentor of both the LLB and the LLM students, and contributed to educational innovations, design of new curriculum, course and technology, mediate teaching learning process, invite as a chairperson in various conferences and seminars. Sir has published more than 30 research papers on the various dimensions of law. Sir has completed his LLB, LLM, NET, and PGDHR in human rights, as well as sir completed his doctorate from Nagpur University, Nagpur. So, with this brief introduction, I request to sir kindly guide us on the topic of introduction of Juvenile Justice Care and Protection Act. Over to sir.
Thank you so much for overwhelming introduction of mine. And I'm indeed thankful to you and your college to invite me on the very burning topic of Juvenile Justice Care and Protection of Children Act 2015. Hope I'm able to share my screen with you. Yeah. So, yeah, hope my screen is visible.
Yes, sir. Yes, sir.
Yeah, great. So, I mean, it's a kind of sorrow I am just keeping in my mind and heart since long. Especially, I remember, instead of jumping directly on the topic, let me clear some background that what exactly I felt when I heard something about juvenile justice system that exists in India. This sorrow is not almost all about that. I am just 40 kilometers away from the place where actual incidents that recently been happened in the form of Disha's case. I'm not worrying about that I'm staying just 25 kilometers away from the place where actual encounter been happened. I'm even not worrying much about whether that encounter was valid or invalid, or I must say planned or natural. I'm worrying about the juvenile justice system that has been introduced especially after the 18th century to almost all the world. Because in that case, almost 2 offenders were claimed to be minor. And then I started thinking about the juvenile justice system. Is this a thing that we plan for juveniles? The child who actually in need of care. A child who is in conflict of law. I must tell you, the statement recorded by NHRC in the same year from the mother and father of the juvenile stating that one of the accused, claimed accused, who is this is right now, was born on 15th of August 2002. And therefore, it almost shaken my mind. I'm just sort of in the pain that we actually not dream for that society. My worry is almost all about the celebration that has happened after the encounter. Being a layman, I can accept that thing, but being a lawman, it's very hard to digest all the things. And therefore, this almost all lecture would be a kind of bird eye view on the juvenile justice system that has been introduced for India. In this context, juvenile, we have to understood as a person who is below the age of 18 years, and juvenile delinquency we have to understood in the context of participation of a minor in an illegal act. So the juvenile delinquent system is almost protect the interest of the child who is in need of care or who is in conflict of law. Now, these are the very, basic terminologies which are included under the Juvenile Justice Care and Protection Act 2015. Now, when I was a student, I actually gone through the Act of 1986 and 2000, but comparatively, this Act is very new, coming with the kind of skeleton of the earlier Act, but very significant changes has been put forward by this Act. So in this present lecture, I'll surely deal with what justice mean to you, what exactly history of legislation concerning the child in need of care. I'll surely go through the reason that why amendment has been happened in the year of 2015. I'll surely go through the scope of the Act, scheme of the Act, surely deal with the juvenile who is in conflict of law, who is in need of care, and some positive and negative side involved into the perspective of that juvenile justice system. And lastly, we'll go to the conclusion. Now, let me ask you one simple question. That if your government is not allowing the child who is below the age of 18 years to drive a car on the road with a license, if your government is not allowing the child who is below the age of majority to enter into a marriage and to form his family, if your government is not allowing a child to cast a vote on favor of the candidate of his own choice, then how you can expect the kind of same system which is there for the adult person who can try in court of law? And that is a very basic argument for introducing that juvenile justice system to the world. Let me tell you that phenomena of juvenile justice system, even though has a very recent development in the India, but it actually started in the year of 1850 in the form of Apprentices Act. But before moving that historical background, let me tell you what justice stands for. I remember a statement that my one professor used to always state about the justice, who always say that justice is not when you are actually contesting the matter on the merit and thereafter someone will decide your matter. Justice is the thing which you get for which you are deserving. So justice is a kind of habit which makes a man capable of doing what he deserving for. But referring to the John Rawls, who is saying that justice is the first virtue of the social institutions. And therefore, the first question that I remember in the context of juvenile justice system, that how a child who is not even allowed to enter into a contract and form his valid consent, then how he can be tried in the same system as a criminal, as a part of any inquisitorial or any kind of acquisitions. So let me tell you a kind of a problem that Indian society nowadays facing. that even though we are coming with the several idea and notions of the justice which has been developed by the Constitution of India, but when it comes to the ground reality, that ground reality could not be, meet with the expectations that required by the law. So equality, even though is a desire of the justice, but fair play is very important while trying a person in court of law or otherwise, as the case may be. So justice is a kind of harmony we have to understand, because even though we are saying that there are a number of legislation that has been introduced for the protection of the children since the beginning of the civilization, I must say. But if you could compare all the legislation, all legislation are talking about protecting the interest in different dimensions. Juvenile Justice Care and Protection Act 2015 is coming with a different idea, which basically talking about how the child should be treated, how the child should be cared, how the child should be, up to some extent be punished, and how the child could be rehabilitated. So this kind of justice is universal, because it may be in the American society or any other Western society, as the case may be. But one common thing is always there, that human child is almost dependent a number of years on the parents. So justice is a human creation. As I said, why justice is a human creation? Because we are introducing a kind of principle, we are introducing certain norms and rules, as I said, in the form of 3 different examples. Otherwise, no one can stop the person to drive a car on the road. Even there are still few marriages that are going on and happening, but these all terms under the illegality of the thing, right? So, in the context of juvenile justice system, if we are understanding the kind of justice, it may be distributive, it may be compensatory, corrective justice, social justice, and procedural justice. But let me tell you the facts. The act which is so introduced in the form of Juvenile Justice Care and Protection Act 2015 is majorly stressing upon the social justice and procedural justice. Surely there are certain corrective measures that are itself adopted by the law, and up to some extent there could be norms that could be available in the form of distributive justice and compensatory justice. Now let me move toward the another point, that is history of legislation concerning the children in conflict of law. Now, as I said, there are a number of legislation that you can find in the context of right of child. But for the time being and for your convenience, I divided all the legislation in 2 different parts. These are pre-independence and post-independence. So, Apprentices Act, Female Infanticides Act, Reformatory Schools Act, Vaccinations Act, Factories Act, Guardian and Ward Act, Child Marriage Restraint Act, you can see before the independence. But when the Constitution commences, and especially if you could look into the provision like Article 15 Clause 3, Article 39 Clause E, and even certain provisions under Article 23, 24 and 25, the 24, basically protecting the rights of the child. So it may be in the form of Immoral Traffic Prevention Act, Merchandise Shipping Act, Motor Transport Work Act. So this Constitution actually given the base and authorized the state to come up with the act with the legislation on a particular points. So it may be in the context of education that has happened in the form of Right to Education Act in the year of 2009. Then there are other similar legislation been introduced for the protection of children. So if you could look into the history, there are a number of states who actually influenced by the British system, because I remember the efforts of Cornwallis, who came up with the idea of RACT school, and first RACT school been introduced in the Bombay. But there was some kind of, I must say, a recommendation by the jail committee around in the year of 1920. Based on that, certain states and provinces came up with the act, which includes the Madras Children Act, Bengal Children Act, Bombay Children Act, Delhi, Mysore, Travancore, and Cochin. But major change you can see in the context of Children Act 1960, because the government at that time introduced this act specially for the protection of the children to almost all territories, union territories of India. But this was not a solid idea where we can uniformly administer the juvenile justice to all the children, and therefore there were certain development that has been done specially after the year of 1992, where the Convention on the Right of Child has been introduced, and the similar convention has been acceded by the India, and therefore it was a kind of implied force by the international community that there must be certain modifications under the existing juvenile justice system. I must not forget to refer the minimum standard rule for the administration of the justice, which actually forced the government to come up with the idea of Juvenile Justice Care and Protection Act 1986. But additionally, I must tell you, in the year of 2002, there are certain kind of improvement that has been done in the Convention of Right of Child. The first one was these two optional protocol. One is protocol to the Convention on the Right of Child on the sale of children for prostitution and child pornography. And second protocol was as to the Convention of the Right of Child who is in involvement or whose involvement is there in an armed conflict. So because of that, this almost entire system has been influenced. But these are not, I must say, sophisticated reasons due to which this 2000 Act has been amended. Because juvenile justice system sometimes used to interpret it as abating the crime by the minor. Because most of the people say that, no, if we are coming with this kind of system, then it will somewhere abate the children to commit a crime, because there would not be any kind of solution and children can get rid easily from the charges. But if you could see the data of NCRB, especially revealed in the year of 2012, you can find that around 1.2 of total crimes has been reported in the year of 2012. Even in 2012, police in India charged around 27,936 juveniles for alleged involvement into the crimes, including murder, rapes, and rioting. Among those who actually faced the trial in front of the Juvenile Justice Board, I must say inquiry for that, 2/3, that is 66.6, were aged between 16 to 18 years. And this was somewhat kind of development that has triggered because in earlier existing act, there was no as such influential and instrumental provisions, and therefore there was some kind of change that was required. But 4 important cases happened in the year of 2012, where a 16-year-old Delhi boy killed in a 4-year-old girl who killed 4-year-old girl. And I hope that you are almost aware about the Nirbhaya's case, Shakti Mills incident, and again the 12-year-old girl who has been raped by 5 boys between the age of 12 to 16 years. So these almost cases created a kind of chaos, and a challenge has been raised in front of the government, and therefore there was a kind of we can say pressure that has been created on the government, and they've been forced to come up with an act. This was one side I told you, but if you could look into the crime that has been committed against the children, that was also a very big problem in front of the government, because if you could see the number of offenses that have been committed against the children, then I must again reveal the data of NCRC, who stated that in Delhi around 2,909 cases been reported where the crime actually been committed against the children who were under the juvenile justice home. Rajasthan reported 2,776, Kerala 2,101, Tamil Nadu 1,486, Haryana 1,081, Punjab 1,068, Gujarat 999, West Bengal 744. Now this number, if you want to know, you can just visit to the site, you will get a clear data about that. Now, when it comes to the Juvenile Justice Care and Protection Act, what exactly the scope of this act? This act is basically dealing with the children who are in need of care and who are in conflict with law. So it basically dealing with the apprehension, detention, prosecution, penalty, and imprisonment, rehabilitation, and social reintegration of the children in conflict with law. Similarly, it also provides the procedure, decisions, or order relating to the children who are in need of care. Now the question is, the children when turned into juvenile, and when juvenile turned into juvenile in need of care and juvenile in conflict with law. Now, if you could look into the major definitions that are there, because under this present act, around 60 different definitions has been given. So this definition of child in conflict with law clearly stated, and which is mentioned under section 2 clause 13, we stated that child in conflict with law means a child who is alleged or found to be committed an offense and who has not completed 18 years of age on the date of commission of such offense. If you could revise, I referred the original Act of Juvenile Justice Care and Protection of Children 1986. At that time, the age was different for male and female, but here 18 years is for both male and female. Now, child in need of care, again defined in section 2 clause 14, which basically stated a child who is found without any home, who is found working in contravention of the labor laws, or who is reside with the person either by his own biological parents or otherwise, who actually injured, exploit, abuse, or neglected the child, or has threatened to kill, injure, exploit, or abuse the child, or has killed, abused, neglected, or exploited some other child, and who has a parent or guardian, and such parent and guardian are unfit to take care of that child. Now, this is almost has to be decided by the CWC and JJB. But if you could look into the provision, that is section 2 clause 14, you will find that there are almost 11 different clauses which basically talking about the child in need of care. So these are who are not in having the parents, or no one is willing to take care of that child, who is missing or run away from home, who has been or is being or likely to be abused, or who is found vulnerable, or who is being or likely to be abused by unconscionable gain, and who is victim or affected by any armed conflict. So these are all kind of children who will directly comes under the purview of juvenile who are in need of care. Now, I forgot to tell you that even though we have had a number of legislation, but one legislation was somewhere based on the line of juvenile justice system, which first time stated that child, even though he has committed a crime, but criminal responsibility cannot be shifted on him if he is below the age of 7 years, because that much of intention would not be developed within that child. Now, if I refer section 83 of Indian Penal Code, which basically comes under the general exceptions of that act, and which stated that when the child is above 7 years, but below the age of 12 years, in that case, he could be subjected to punishment. Now, subject to condition that he must have to develop the sufficient maturity of understanding at the time of commission of the offense. But after inquiry, if it found that he had not sufficient maturity of understanding, then he can get rid of his criminal liability. But what about those children who are between 12 years to 18 years? Now, I must tell you that IPC is a bit silent on that. Now, what Juvenile Justice Act is talking about, because as I must tell you that we have actually leave the hand of common law system, and we took the American judicial system under the head of parent patria model, where we are almost trying to take care of the children by way of instrumentality of law. Now, this act, if you could look into the preamble of this act is basically talking about 5 important things. The first one is care, protection, development, treatment, and social reintegration of the child. Now, we have to understand this particular act with the connotations of each and every point one by one. Now, this is a very common question if I ask you that how this act is taking care of the child, or how this act is protecting the interest of child, how the act is looking toward the welfareness of the child, how the act is providing the treatment to the child, and what is the mechanism for social reintegration and rehabilitation of that child. Because if you look into the object, almost all object is basically triggering your mind toward the rehabilitation and bringing back to those who are in conflict with law or who are in need of care to the society. Now, the question is how the act is taking care of the children. And I'll tell you, if you could look into the provision of section 2, as I stated, there are a number of definitions given. Out of that, best interest principle is almost defined that in almost all cases, the child must have to be seen with respect to his best interest. So whenever there is a chance that his interest is going to be affected, he must have to be allowed to be participated into the proceedings, and his education, his food, his residence, almost all has to be managed. Secondly, child care institution. Now, if I am saying about the child care institution, there are a number of institutions that are introduced in the form of CWC, in the form of Juvenile Justice Board. They will, provide a kind of service where child's interests can be taken care, and almost all benefit will be tried to ensure for the interest of children. It could be offered by way of child home, open shelter home, observation homes, special homes, safety homes as well. Because let me tell you the incidents, because I actually encountered with that evidence, with that incidents, and I was actually present over there, and one child who actually stolen some pockets of chips from one shop, and who actually ran away just out of the village. And the people of that village actually captured that person, and they started beating that child. Now the question is whether this child is in need of care or he is in conflict with law. Because the offense, whatever he committed, is very petty in nature. He has committed it because of he was subjected to hunger. But people started beating him. The second incident, I must tell you that if there is a child, I am just telling you the example. If there is a child who actually ordered by his father to go and prepare the glass of liquor or pack of liquor, I must say, for him, to which the child denied, and the parents thrown stick toward him. In that case, whether the child fall under the category of in need of care or in conflict with law. So if you could match up the incidences with the number of incidences that are given under section 2 clause 13 and 2 clause 14, you will certainly find out that if a person encounter with any one of the offense, either directly or indirectly, he becomes in conflict with law. But in almost all cases, the Juvenile Justice Board and CWC will try to protect the interest by way of, shifting him into shelter home, observation home, special homes, and certain specialized agencies are also been introduced, especially when the CWC and Juvenile Justice Board ensure that the child is fit to give in adoptions. So this almost all power are given to the state that they can determine the agency to give the children in adoption. Juvenile Justice Police Unit. This is a very interesting feature. Nothing has been changed because the earlier act similarly been accepted as a kind of skeleton sketch. But here the special police juvenile unit has been introduced. By that way, he will not be apprehended by the normal police, and he can be apprehended by special juvenile police unit, who will produce the child to CWC when he is in need of care, or produce the child to Juvenile Justice Board when he is in conflict with law. And state government is also similarly defined under Juvenile Justice Care and Protection Act. Now, the second question is how the Act of 2015 protect the interest of children. Firstly, we gone through the care, that how they are providing the care and taking the care, what are the instrumentability that are available under the Act. Now, in this segment, we have to see that how this Act is protecting the interest of children. So when I actually gone through the numbers and numericals that has been shared and revealed by the NCRC, particularly offenses that has been committed against the children, it was found that there is a need to protect the interest of children, especially at shelter homes or wherever they are placing. But if you could look into Chapter 9 of this Act, there are around 8-9 offenses are introduced, which could be termed as an offenses against the children. Now, out of that, first one is prohibition on the disclosure of the identity of children. Now, in this case, we have to understand that no system like CWC or Juvenile Justice Board or Children Court will disclose the name of a child, and his name will keep confidential unless and until revealing of name is so required for the best interest principle. Secondly, there is also a punishment for cruelty to child. Further, there is a punishment for the employment of a child for begging. Now, for that purpose, begging is also defined under Section 2, which basically stated that when a child arms or enter into the premises, private premises, or demanding money in public places, this would amount as a begging. But when a child is forced and coerced to be a part of that begging, in that case, this would amount as an offense, and ultimately it is a very serious offense punishable under this Act. Then penalty for giving intoxication and narcotics drugs to the child. One of my friends asked me that whether offering the tobacco to the children would amount as an offense or not. The answer is yes. Under the provision, offering the tobacco would also amount as an offense. So subject to condition that it must not be suggested by the medical practitioner, and it must be intentionally so for that purpose. Though use of children for supplying the drugs, this is also very serious offense. And in this way, the Act tried to protect the interest of children in almost all the offenses which can be caused against them. Then there are certain punitive measures for adopting the child without following the prescribed procedure. Now, under this Act basically talking about the rehabilitation, as I stated, but there are certain kind of procedures which we can understood on the line of Adoption Regulation 2017. There are certain agencies which has been affirmed by the central government and state government who can allow the CWC or Juvenile Justice Board or Child Court to give the child in adoption. Then punishment for procurement of the children for any purpose. Then corporal punishment. Now, what is corporal punishment? Whenever any child protective homes or orphanage homes are punishing the children on the name of discipline, this would amount as an offense under this Act. And therefore, this Act basically not only covered those offenses which has been triggered against the child by the outsider, but by those who actually in custody of their children. Further offenses committed as disabled children. Now, this is very, very serious offense under this act, because for that offense, double punishment is provided. Twice punishment has been offered for that. So if the actual offense is punishable for three years, and if someone is committing the offense against the disabled children, in that case, this offense would be punishable twice. So these are the kinds of protection which has been ensured by the Act under Chapter 9. Now, third segment of my presentation is how Act ensure the development of the child. As I almost stated, that there are certain agencies which have been introduced under this Act, which include the Child Welfare Committee, which basically taking care of the child who is in need of care, Juvenile Justice Board, who is looking toward the matter of child in conflict with law, and Children Code. Now, this is a very interesting thing which has been introduced by the Juvenile Justice Care and Protection Act 2015. A child in conflict with law who has committed heinous crimes. Now, this Children Code is basically introduced because I remember the Protection of Child Right Act 2005 also demanded a kind of special code for the children. The same act, that is Juvenile Justice Care and Protection Act, ensure the same principles, stating that there must be Children Code. So referring to the this Protection of Children Act 2005, which actually designated a session code as a children's code, the same principle been adopted over here, and the session code could act as a children code when a child in conflict with law committed any heinous crime. Now, this heinous crime is a very new kind of category which has been introduced by this law. Because as far as categorization, as I know, which is given under CRPC, we can say that one offense could be bailable, non-bailable, or compoundable, non-compoundable. But here you can see different kinds of category. One is a petty offense, another is serious offense, and third one is heinous offense. I'll come to that back. One is simple offense, heinous offense, and serious offense. Simple mean petty offense. Now, I'm just moving toward the another segment of my presentation, which basically talking about the treatment, that how the act providing the treatment to the children. Now, treatment to the children, we have to understand on the line of principle of 3 P's. Now, what are those 3 P's? First P, basically talking about the principles. Now, what are those principles which are given under the Juvenile Justice Care and Protection Act? Secondly, procedure. Now, if I'm saying that I committed petty offenses, I'm not a child, but being a child, I committed petty offenses, what kind of punishment would be there for me? If I committed serious offenses, what kind of punishment and procedure would be there for me? And if being a child, I committed heinous offenses, then what kind of punishment and procedure would be for me? And this is a very kind of gist of the act, I must say. And third P is basically talking about the punishment. So for the purpose of punishment, I must tell you that you must have to refer section 20 and 21, which is very much important, and go to the context of Juvenile Justice Care and Protection Act. Now, as far as procedure is concerned, CWC is basically, as I said, talking about child in need of care, which is given under Chapter 7 from section 31 to 38. Juvenile Justice Board, which is given under Chapter 3 from section 4 to 9. And Children Code, which is given under Chapter 4 from 10 to 26. Now the question is, okay, petty offenses could be tried by this, tried in the sense inquired by the CWC. Serious offenses could be inquired by the JJB. But what about that heinous offenses which are punishable for more than 7 years? Now let me tell you the first P what is basically talking about, because I'll come back to the procedure, I'll come back to the punishment, but let me tell you that what kinds of principle being introduced under section 3 for the protection and benefit of the children. Now, this is just a part of procedure. Otherwise, presumption of innocence. Now, if you could look into the Indian Evidence Act, there are certain kinds of presumptions that are given under Section 100 onward, I must say. But here, spatially, certain presumption has been chalked out by that way the children's interest must not be affected. So presumption of innocence, until the child proved guilty, he must not be presumed to be an offender. Secondly, dignity and worth. This is very universally and the protected principle by the human right that we must have to respect the dignity and personality of that person. Third one is principle of participation. Now, principle of participation is basically talking about allowing the child to participate into inquiry. So he must not go unheard. He must not be punished without getting the chance of hearing. And therefore, in almost all cases, his appearance must have to be ensured. Then positive measures for the protection of that child, by that way his maximum interest can be looked after. Principle of non-stigmatization. Now see, this is a very, very important principle that even I shared earlier also, that we are not supposed to disclose the name of child who is in conflict with law, or who, even though coming as a witness in any proceeding. So witness protection is also somewhere ensured under this act. Then non-waiver of right, that person is or he must not allow to waive the right, in the sense that his interest must have to be taken care, and there must be insurance of the natural justice principle in the form of odi alteram partem and other principles that are there for the purpose of protecting the interest of accused otherwise. Then, as I was talking about the procedure, this procedure is basically given under Section 14 of the Juvenile Justice Care and Protection Act. I will not go much in detail, but let me tell you very important clauses which are there in the form of section clause 5, subclause D, E, and F. Now, what is Section 14 and what is clause 5, subclause D, E, and F? Now, this is the section which basically talking about the inquiry by the board regarding the child in conflict with law. And if you could give a bare reading, you will understand that the board shall take the following steps to ensure fair, speedy inquiry, namely in cases of petty offences shall be disposed by the board through summary proceedings as per the procedure prescribed under the Code of Criminal Procedure. So I just want to stand myself correct that even though it is petty offence, it will be tried by the, and I mean inquired by the Juvenile Justice Board. So CWC basically taking care of those children who are in need of care, and which mentioned under Section 2 clause 14 from almost all around in 11 different clauses, subclauses. Then moving further, inquiry of serious offences. Now this again providing the procedure which ensure that serious offences shall be disposed of by the board by following the procedure for the trial in summons cases. Now, let me tell you what is summons case and what is summary proceeding. Now, if you want to get acquainted with that, please look into section 251 to 259 for the purpose of summons cases, and please look into section 260 for the purpose of summary proceeding. These all sections I'm talking about the CRPC from section 251 to 259 and from and section 260 for summary proceeding. Now there is another important provision, inquiry of heinous offences. Now for child below the age of 16 years on the date of commission of the offence shall be disposed of by the board under clause E, and for the child above the age of 16 years as on the date of commission of the offence shall dealt with the manner prescribed under the section. Now again, children has been categorized. As I told you, in the context of category of a children, first one is 7 years, where he could be considered as a dolly in capex, where he would not be liable for any offence. Second category from 7 to 12, where a person can consider as an offender when he is developed sufficient maturity of understanding. Now, I'm not directly connecting this provision with the provision of IPC, But I just want to refer the Justice Verma committee report, which basically talking about the juvenile justice and punishment for those who are above the age of 16 years but below the age of 18 years. And almost all chaos has been created on that ground only because nowadays children are very advanced, and they almost develop the kind of sense and understanding about the consequences of their act. So in that case, if the child is below the age of 16 years, it would be charged, or it would be inquired as a part of serious offense by the board. But as in case of heinous offense, it could be tried by the children code. Now for that purpose, section 19 has been given. Section 19 basically talking about the powers of the children code. And these powers are in conformity of the procedure which has to complied by the Juvenile Justice Board by referring to section 15. So whenever a child comes in conflict with law and who is above the age of 16 years but below the age of 18 years, that first assessment of his age and understanding must have to be done by the Juvenile Justice Board. But this would not suffice, because referring to section 19, after the receipt of the preliminary assessment from the board under section 15, the children court may decide that there is a need for the trial of a child as an adult as per the provision of the Code of Criminal Procedure. And thereafter, if they consider that there is a need to try that child as an offender, in that case, they will pass appropriate order subject to the provision of section 20 and section 21 of Juvenile Justice Care and Protection Act. Now, what is section 21? Now, section 21 basically talking about that no child in conflict with law shall be sentenced to death or for life imprisonment. So let me clear the thing that even though the offense, heinous offense, is inquired by the children code or tried by the children code, even though the person found guilty, at that time, the death sentence and life imprisonment would not be awarded. I was talking about the Justice Verma committee report, especially who actually against the punishment or providing the punishment of the children who are above the age of 16 years, because they were worrying about the future of that child. Because even if we are putting the child behind the bar at the time when he is below the age of 18 years, or even at the time of 18 years, and tentatively, if we are counting the period of life imprisonment as a 14 year, so he will back toward the society in around 30 or 35 years. So at that time, it would be very hard to get him adjust into the society. There would be kind of stigmatization of that person, and therefore, it is stated that without the possibility of release. So this is a kind of very gray area which need to develop and interpret by the Supreme Court or any other court for the time being in force. Now moving toward this section 245, sorry, 2 clause 45, 2 clause 54, and 2 clause 33, which basically define about the petty offenses, serious offenses, and heinous offenses. Now, petty offenses are those offenses which are punishable less than 3 years. Serious offenses are those offenses which are punishable more than 3 years but less than 7 years. And section 2 clause 33 basically talking about heinous offenses which are not below the 7 year. Means ultimately when the imprisonment is for the 7 year or more. Now in that context also, there were kind of confusion in the mind of judiciary, because if I could refer certain judgments of the Chhattisgarh High Courts or Delhi High Court, in that context, I found that this area also need to be developed, because in 2018 around, there were few petitions has been filed in a Supreme Court stating that there must be 4th category of the offenses, because if I refer section 120 and 120A and even 121, basically talking about the waging war against the state, in that case, minimum sentence is 10 year. Whether there is a requirement of that 4 category or not, that is also a question that we need to entertain. But as far as the treatment is concerned, CWC, as I stated already. Now, moving towards section 12, which basically talking about the bail provision. So there is a provision for ensuring the bail with or without surety, bond, that has to be looked after by the children court. But again, there is a kind of gray area as far as anticipatory bail is concerned. So that need to address by the time. So I'm just moving toward another procedure relating to the adoption, because we have to somewhere. Someone want to say something?
I request to the participant, kindly mute your audio. Sir,
Okay.
please.
Okay, no issue. So, almost I told you about the role of Juvenile Justice Board, about the role of Children Court, but what exactly CWC is doing. So if you could look into section 30, it basically talking about taking cognizance of and receiving the children. Now, let me tell you, just 4 days back, I received one video where one person who has hold the hand of that girl and who was trying to tell the people that she's the girl who is the daughter of someone and who has abandoned that child. Now, please communicate to the parents. Now, let me tell you, if you are finding these kinds of cases, better to hand over these children to the CWC. They will find out the parents and they will hand over the custody of the children, and they will keep watch further, conducting inquiry on all issues relating to and affecting safety. As I even already given you the example regarding that, when some accident been caused by the child who is below the age of 18 years and who does not have the license, in that case, there is almost chance to have the beating by the society. And thirdly, this CWC is also looking toward the interest of the children for the purpose of rehabilitation by way of adoption. So these are kind of authorities that are actually dealing by way of procedures for the adoptions and all. Let me give the another kind of observation by the Supreme Court in Bachpan Bachao Andolan. In this particular case, it has been clearly stated that rehabilitation will be the measure of success for the Juvenile Justice Act. But if I could refer the kind of problem that entire justice system is facing nowadays, that almost children courts are overburdened. If you could refer the ratio of offenses that committed by the child, you will find out that these children courts and this Juvenile Justice Board are almost overburdened. So in that case, it would be very hard to take care of the interest of that child. And therefore, there is a kind of amendment suggested in the year of 2018, and bill is pending in the parliament regarding that. So they are trying to introduce a collector to act as an authority who can identify the fit person who can give in adoption. So this is just a few highlights. Juvenile Justice Board, how they are constituted. Judicial magistrate of first class plus 2 social workers. Out of that, 1 would be the female. So this is a kind of constitution and few highlights. Children in a session court notified under the Commission for the Protection of Child Rights Act. So ultimately, what I want to say that there are still few gray area which need to cover. As far as the constitution of Child Welfare Committee is concerned, it would be constituted by 4 members. 1 would be, chairperson and 4 other members. Out of that, 1 would be female, who having the experience in a social field of 7 years. Now, there are 2 different agencies who actually working while giving the children in adoption. They are SARA and CARA. So SARA basically talking about State Adoption Resource Agency, and CARA is Central Adoption Resource Authority. There is also a provision for appeal and revision. So basically, appeal of CWC and Juvenile Justice Court would be preferred to the Children Court, and in case of revision, we can move toward the High Court. This is just a bird eye view where you can somewhere identify the kind of provision. As I said, chapter 1 is basically dealing with the preliminary, including section 1 and 2. Chapter 2 basically dealing with general principle, which covers section 3 and number of principles which has been identified over there. Chapter 4 basically, chapter 3 is basically dealing with the Juvenile Justice Board. Chapter 4 dealing with the procedure in relating to the children in conflict with law. Chapter 5 is dealing with the Child Welfare Committee. Chapter 6 is dealing with the procedure in relation to the child in need of care. Chapter 7 is dealing with the rehabilitation and social reintegration of the child. Chapter 8 is basically dealing with the adoption. Chapter 9 basically dealing with the offenses against the children. And these are the miscellaneous provision. So even though these are miscellaneous provision, but don't underestimate this, because there you can find the provision of appeal. Even in that case, a collector, district collector could be considered as an aggrieved authority where grievance can be submitted by the aggrieved party. So this is the kind of bird eye view to the Juvenile Justice Care and Protection Act. Let me finish within a minute. Thereafter I would be open for the question. There are certain major issues that are involved because in July 20th, 2018, there were around 629 cases relating to passing of order for adoptions were pending. And it was very hard to the court to, given that stamp because of they are busy with their routine works. And therefore, they are stating and demanding some other authority who can work effectively on that line of rehabilitation. Further, in the year of 2020, on January 9th, there was another decision came up in the form of Shilpa Mittal versus State of NCT of Delhi. Because in that particular case, the gray area which I highlighted in the form of fourth category, whether this is so required. So in this particular case, it has been clearly stated that the act is itself clear on the line of punishment, even though the minimum punishment is 10 years, but you have to give the interpretation in such a way where the provision of the act would be effectively implemented. So ultimately, what conclusion was that even though it is not comes under the fourth category, but if it is more than 7 years, then it will be tried as a heinous offenses. Now, there is a gap of implementation as well, because even though we are introducing Juvenile Justice Board, CWC and all, but if you could go to the ground reality, you will find that there is nothing except 2 chairs, two benches and all. So, kind of facility provided by the government are not to the mark and which need to improve. Further, even though there are certain policies for the rehabilitation, but we have to make it more effective by way of giving the effect. Let me refer a judgment given by the Supreme Court in the case of Sampurna Bahura versus Union of India. In this particular case, it has been clearly stated that unless and until the provision of Juvenile Justice Care and Protection Act has been implemented, till that we will not presume ourselves to be a competent citizen, diligent citizen, because it's our constitutional responsibility to take care of the future of the India. I'm quoting to Nelson Mandela, who stated that children are the future of nation, which must not perish at any cost. Otherwise, your nation must be ready for the perishment. So with this, I want to stop over here and I would be open for the questions. Thank you.
Thank you, sir.
Yeah.
I request to the participant, if you have any questions, please put into the chat box. There is one question from our law college, that is an Altaf and Aftab is asking whether the delinquency hearing is a confidential.
Yeah, hearing need to put confidential because as far as the children are concerned and as far as women are concerned, especially heinous offenses are concerned, I must say, in almost all offenses, we must have to give camera in proceeding and it would be confidential. Even in that case, record would be disposed of if it is not so required for the future. Thank you, Altaf. Any other question so far?
There is no more question, sir.
Okay. Okay. Thank you so much.
Thank you, sir. There is one announcement. Tomorrow we have Dr. Nital Nandedkar, Principal of VN Patil Law College. Madam will speak on the topic of plea bargaining on the same time. I will share the link for tomorrow's lecture. So thank you very much, sir. On behalf of management, staff, and students, I am very thankful to the Umbarkar sir who deliver a very informative lecture on the Juvenile Justice Care and Protection Act. And I also thankful to Dr. C.M. Rao sir, the principal of MP Law College, and I am thankful to all the participants who joined the meeting and enjoy the intellectual feast. I am thankful to the entire staff of MP Law College. With this, thank you very much, sir.
Thank you.